ready.
Okay, good morning, everyone. Welcome to the February 13th, 2024 Corrections Policy Committee. Before we get started, I'm going to read the administrative announcement. This is a public meeting subject to public meeting law, and it will be digitally recorded. Deliberation of issues will only be conducted by Corrections Policy Committee members unless permitted by the chair. Remember to always state your name for the record. For cases dealing with denial or revocation, only information contained in the staff report can be considered once the staff report is adopted. Assumptions, outside knowledge, or personal experiences should not be included in any discussion. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive or leave the meeting. Additional measures may be taken to have disruptive individuals removed if their continued presence poses a safety risk to the other persons in the room or makes it impossible to continue the meeting. All right, we're good.
All right, is it working?
Yep.
Okay.
Thanks, sir.
So I have new procedure calling roll that the staff will call roll. If not, we can just go around like we've always done. Okay, over to my left.
Aaron Reyes, Superintendent, Department of Corrections, Two Rivers Correctional Institution.
Mark Warren, public member.
Jennifer Cameron, non-management role probation.
Lee Eby, Representative Oregon Sheriff's Jail Command Council.
Ted Langley, Oregon Sheriff's Jail Command Council.
Ryan Steffen, representing Michael Reese, Director of the Department of Corrections.
Margo Bowden, non-management corrections.
Eric Riddell, Criminal Justice Office Specialist with DPSSD.
Jennifer Lavario, Professional Standards Compliance Coordinator, DPSSD.
Melissa Langacho, DPSSD Compliance Standards, Verification Standards Compliance Coordinator. Sorry.
Phil Castle, DPSSD.
Catherine Calpine, DPSSD Professional Standards Division Director.
Matt English, Sheriff, representing Oregon State Sheriff's Association. And Samantha, do you want to introduce yourself?
Samantha Cosa, DPSSD Executive Support. And virtually we have Member Frost. Can you introduce yourself?
I'm Officer Frost. I'm at Snake River, and I am a non-management staff committee member.
Member Hunter.
Sorry, was that me? Nick Hunter. I'm the Marion County Sheriff representing the OSSA.
Member Shivers.
Officer Shivers, non-management DOC.
Member Tabor.
John Tabor, the Interim Professional Development Unit Administrator for the Department of Corrections.
Guest Susan.
Susan Ramos, was with DOC.
Assistant Academy Dean, Center for Student Excellence Manager.
Sam Henry, Communications Coordinator. Brian Henson, DPSSD.
Jennifer, DPSSD. Compliance Coordinator.
And
Shelby Wright, Executive Assistant, DPSSD.
All right, thank you. Did everybody have a chance to look at our November 7th minutes? Is there any corrections, deletion changes? Meeting minutes.
on a motion to approve the November 7th, 2023 meeting minutes, Chair English.
Aye.
Committee Member Cameron.
Aye.
Committee Member Eby.
Aye.
Committee Member Frost.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Steffen.
Aye.
Committee Member Reyes.
Aye.
Committee Member Shivers.
Aye.
And Committeemember Tabor.
Aye.
Motion passed.
Thank you. All right, we will move into administrative closures on our consent agenda presented by Jennifer Lavario.
Thank you, Chair English. Good morning, members of the committee. We have 4 administrative closures that we're recommending to the committee for on the consent agenda. They can be ratified by 1 vote. Chair English.
Any questions on the consent agenda items? All right, I would entertain a motion to adopt the consent agenda as presented.
Thank you for the record. I motion that we accept the consent agenda as presented.
Thank you.
Brian Stefano, second.
Thanks.
Voting on a motion to approve the administrative closures, Chair English.
Aye.
Committeemember Boren.
Aye.
Committeemember Bowden.
Aye.
Committeemember Cameron.
Aye.
Committeemember Eby.
Aye.
Committeemember Frost.
Aye.
Committeemember Hunter.
Aye.
Committeemember Langley.
Aye.
Committeemember Stefan.
Aye.
Committeemember Reyes.
Aye.
Committeemember Shivers.
Aye.
And Committeemember Tabor.
Aye.
Motion passed.
Thank you. Okay, we have a very packed agenda cases today, and there are a lot of people that are present both here in the building and via Teams. And so we're going to kind of skip around a little bit. On Teams, we have Susan Ramos, so we're going to move to that case first, which is number 10 on your agenda. And I will turn it over to Jennifer.
Thank you, Chair English. Jennifer Lavario for the record. Case before you is that of Susan Ramos. On January 24 of 2022, Susan Ramos was arrested for felony assault for domestic for assaulting her significant other in a Target parking lot in full view of her minor child. The information was provided to the district attorney, who determined no charges would be filed. On March 31st of 2023, Ms. Ramos resigned in lieu of termination from the Oregon Department of Corrections after being investigated for allegations of misconduct related to her arrest for felony assault. Ms. Ramos received a disposition of threat of harm to minor child by Child Protective Services. The department determined Ramos violated the board's moral fitness standards as follows. Dishonesty. Ms. Ramos' statements to the police and DOC investigators were inconsistent and were evidence of her reckless disregard for the truth. The department did not find any misuse of authority. The department found misconduct. Ms. Ramos caused harm to her significant other by punching and scratching him in a Target parking lot. Ms. Ramos caused harm to her minor child by allowing her to witness the physical abuse of her significant other, as confirmed by findings of Child Protective Services. Ms. Ramos admitted to investigators that she and her significant other had been drinking when they drove to Target with their minor child in the car, which could have caused harm to them and others. Ms. Ramos harmed the reputation of all law enforcement officers by making light of the impact of her actions had on the safety and well-being of her family and others. Ms. Ramos made threatening statements about what she would do to her significant other when she returned home during her interview with law enforcement officers. The department submits its determination to the policy committee to affirm, modify, or negate its moral fitness violations. Chair English?
Thank you. And I understand that Ms. Ramos is on today, so I will turn that over to you for her to give mitigation.
Thank you. Ms. Ramos, can you hear me?
Yes,
Are you prepared to provide your statement?
I am.
Okay, I'm going to set our timer for 5 minutes. Are you ready?
I am.
Okay, go ahead.
Hello, I'm Susan Ramos. I was currently working for DOC, and I wrote something. I sincerely apologize for the off-duty incident that occurred on July 24th, 2022, which led to my arrest. I deeply regret the actions that took place and understand the gravity of the situation, especially concerning my position within the Department of Corrections. I want to emphasize that I was never charged or convicted in relation to this incident. I maintain a clean record. However, I am fully aware that being arrested still reflects poorly on the department and casts a shadow on my commitment to upholding the standards expected of me. It is essential to provide context to this incident by stating it was an act of self-defense. The circumstances leading to the arrest unfolds in a way, that required me to defend myself. And while I deeply regret the escalation of the situation, I want to make it clear that my actions were driven by a genuine concern for my safety. I must express my profound remorse for the fact that this incident unfolded in front of my child, causing both of us unnecessary trauma. This is a situation that should have never occurred, and I am acutely aware of the impact it has had on my child's well-being. I understand the importance of maintaining the highest level of professionalism, both on and off duty, and I have failed in this regard. In response to this incident, I have taken proactive steps to address the underlying issue. I have completely eliminated alcohol from my life and undergone counseling to ensure that I learn from this experience and prevent any similar awareness in the future. The incident has been a wake-up call, prompting me to reevaluate my choices and behavior. Working for DOC has always been my goal and dream, and I am committed to providing that I am capable of upholding the standards and responsibilities associated with this career. I have learned from my mistakes, and I am dedicated to moving forward with a renewed sense of responsibility and professionalism. I understand the disappointment my actions may have caused, and I carry this disappointment with me every day. I am determined to rebuild trust and demonstrate through my actions that I am fully committed to the values of the department. Thank you for the time, for listening, and consideration. My apologies.
Thank you. Okay, we will open this case up for discussion. Also, during the discussion, should include identifying any aggravating or mitigating factors in this case.
Levy, for the record, aggravating was the fact that not only was it domestic violence, but it was assault in front of children. Also aggravating was the fact that there was numerous occasions during the internal investigation of untruthfulness, changing the story of what was originally reported to the Salem Police Department at the time of the incident. Mitigating was that they chose not to file any official charges at the time.
Brian Stephan, aggravating was that she identified herself as a corrections officer when the police responded to the incident.
Matt English, for the record, aggravating also was employed at the time as a corrections officer.
For the record, also aggravating was the fact that there was admission of drinking and driving to the scene where the incident occurred.
Brian Stephan, aggravating, it appears that she knew the blood on her face wasn't hers. She didn't have a question about whether it was hers or his. She knew it came from him.
Ted Langley, for the record, it's already been established that she identified herself as a corrections officer. I find also aggravating that even after identifying herself as a corrections officer, she still openly threatened retaliation against the other person involved in it.
Any other aggravating or mitigating?
Nick Hunter. I kind of have both, Mr. Chair, in that coming from the fact, sorry, go away here. Coming from the fact that it's a mitigating on the side based on Ms. Ramos being here today and making a statement. During that statement, I did not hear any sort of accountability for the actions that were actually taken that day. So I think the lack of accountability provided in the statement and lack of accountability provided throughout the entire investigation is an aggravating factor.
Margot Bowden, aggravating, reading the DHS report on 10/19/22. She states that since the incident, she states that she barely drinks and she may have a beer or two twice a week, and she just said that she doesn't drink anymore. So and that was several months after the incident.
Any other aggravating or mitigating? Jennifer, could you count what we have identified so far, please?
Sure, Chair English. Mitigating, she chose, the DA chose not to file charges. Mitigating that she came and made a statement today, which was also identified as aggravating, as the statement did not include accountability for what she did during the investigation. Aggravating, this was a domestic violence assault in front of a child. Aggravating, numerous untruthful statements during the investigation. She ID'd herself as a corrections officer, and even after she did so, she continued to threaten retaliation towards the person identified in the incident with her. Aggravating, she was employed at the time. She admitted to drinking and driving to the scene. She knew the blood on her face wasn't hers, but that it came from her significant other. DHS report states that she stated that she barely drinks and has a beer twice a week, and she stated in her statement today that she doesn't drink anymore. Did I accurately reflect that last part?
Yeah, because it was in July and that was in October.
Okay.
That's what I heard her say, is that she omitted alcohol from her life. But in October, she's saying she still drinks.
If there are no other aggravating or mitigating, I would entertain a motion to adopt the staff report and the factors that have been identified by the committee.
Brian Seven, I'd like to add one aggravating. It was already mentioned that it was in view of the daughter. And the daughter did say that mommy got mad and went grr, and then there was blood, and the child was scared.
Okay. Thank you.
Nick Hunter, I'll add to that as well, that during the statements there was an initial questioning of where the daughter was, and that she only made the statements that she made in front of the, I guess, fiance or boyfriend in this case. And that was an untruthful statement because the daughter was nowhere near the boyfriend or the fiance at the time that those statements were made.
Okay, I would entertain a motion to adopt the staff report and the aggravating and mitigating factors identified by the committee.
Totally for record, I make a motion we accept the staff report and the factors listed.
Thank you for the record, I'll second that.
Thank you.
All right, voting on a motion to adopt the staff report. Chair English.
Aye.
Committee Member Boren.
Aye.
Committee Member Bowden.
Aye.
Committee Member Cameron.
Aye.
Committee Member Eby.
Aye.
Committee Member Frost.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Seven.
Aye.
Committee Member Reyes.
Aye.
Committee Member Shivers.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Thank you. All right, any further discussion? Next, I would call for a motion whether the committee should recommend to the board action or no action in this case.
Mr. Chair, Aaron Rice for the record, I move that we take action.
You?
Levy for the record, I'll second that motion based on the aggravating factors, both untruthfulness and the assault that occurred at the time in front of children.
All right, it's been moved and seconded to recommend action in this case.
Voting on a motion to take action. Chair English.
Aye.
Committee Member Boren.
Aye.
Committee Member Bowden.
Aye.
Committee Member Cameron.
Aye.
Committee Member Eby.
Aye.
Committee Member Frost.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Seven.
Aye.
Committee Member Shivers.
Aye.
Committee Member Reyes.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Thank you. Now that we have voted to recommend action, open the floor for discussion regarding the amount of ineligibility period. The first motion should include why the specific timeline is being recommended.
Levy for the record, I would motion for a lifetime based on the aggravating factor that was found to be untruthfulness, along with the assault and the infraction of children. With truthfulness brings itself a lifetime ban.
Okay, there's a motion on the floor for
Nick
recommendation.
Hunter. Nick Hunter, I would second that motion from that's on the floor right now based on lifetime ban, stating some of the same facts that were just stated with the investigation the way it was, the dishonesty that was included, the fact that it was in front of a minor child when it was done, and restating my original piece on the accountability that lacked during the actual investigation and lacked in the statement today.
Thank you.
All right, we are voting on a motion for a lifetime ineligibility period. Chair English.
Aye.
Committee Member Boren.
Aye.
Committee Member Bowden.
Aye.
Committee Member Cameron.
Aye.
Committee Member Eby.
Aye.
Committee Member Frost.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Steffen.
Aye.
Committee Member Reyes.
Aye.
Committee Member Shivers.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Thank you. Yeah. Okay, Ms. Ramos, thank you for your time. You're excused. Okay, we will move on to Tina Earhart.
Thank you, Chair English. This next case before you is that of Tina Earhart. Tina Earhart is currently employed by DOC at the Santiam Correctional Institution. Tina Earhart notified the department that she was arrested for harassment, domestic violence on August 24 of 2022. On August 25 of 2022, an arraignment was held over and with no entry of plea. On September 22 of 2022, the case was dismissed as further investigation revealed it would be in the interest of justice that the action be dismissed. The department requested the records related to the arrest to review them for moral fitness violations and determined Ms. Earhart violated the board's moral fitness standards as follows. No dishonesty, no misuse of authority. We did find misconduct in that Ms. Earhart threatened harm to another by pulling the beard of a person and making threatening statements expressing wanting to harm him. The department submits its determination to the policy committee to affirm, modify, or negate its moral fitness violations. And as you can see, Ms. Earhart is here today to provide her verbal mitigation. Ms. Earhart, are you prepared to do so? Yes. I would just remind you that this is not a dialogue between you and the committee. It'll just be a 5-minute statement by yourself. Okay? And go ahead.
I am Tina Earhart. I'm a correctional officer at Santiam Correctional Institute. In 2019, my youngest brother, Gary, is my half-brother. His common law wife called me to let me know he was in the hospital with cancer. And so I committed to visit him and reinstate a relationship with him. I'm looking back at both brothers that I have had no relationship with my brothers for at least 42 years that I'm looking at. When I left that home, it was a family of alcohol abuse, just abuse, verbal, physical, mental. It was a lifestyle that did not commit to my moral standards, so I left that behind. As far as I'm the middle sibling of 5, and I just walked away from that life. During the course of the last 4 decades, I've taken on the role of helping my family financially and in family crisis. So when I reconnected with my brother, I was very excited about that. And even though it was in the controlled environment of the hospital, I visited him every single day that he was readmitted or I love my brother. The last time he was in the hospital, his wife abandoned him in the hospital, so I opened up my home. He was at hospice level, his disease. He was very active, but the way that his end of life was to come about was to bleed out. So I took on the responsibilities of helping my brother and take care of him the best I could. And my hope was to hold his hand when he took his last breath. I love him. I take every ounce of responsibility of when I snapped, when he was threatening me and trying to manipulate me into giving him a prescription that wasn't even in his previous prescription, because the day after I took him in, he asked me to pick up his prescription, not even thinking about it. I handed him 6 weeks of opiates. I've never seen the face of addiction, and within just several days, I could not even be in my home. I lived across the street with my best friend Katie behind me, and I actually, when we changed posts, changed the shift to graveyard so I could just run across the street if he needed help, because I really wanted to be there for him. I just couldn't. We were not in a place that we could even talk to each other. They've talked several times about my temper, but if you see that they're stating it as when we were kids, I again have to reiterate that I haven't had a relationship with neither one of those brothers in 4 decades. The reason they were both together in my house at the time was I had him at hospice level, and my brother was close enough to come see them. They were the only ones in my family that were close to each other. And so when he moved into my home, my brother Dennis lived very close and came to visit him. I again loved my brother, and that was the only thing I wanted to do was to hold his hand when he passed. But when the face of addiction is in your face, I literally did snap. I did not pull his beard. I just framed his face, and I just wanted his attention because I was asking him why he was trying to ruin my life. I have not a blemish on my record. I have never gotten in trouble, and I've not even had a speeding ticket. And here I am. I feel very upset about what happened in my home, but I could not morally give him the medication. It would be against my moral status as a correctional officer. I could not give it to him, especially when he was. And after I did frame his face and let go, it wasn't like seriously just enough to say that. That's when he started to threaten me, and he started to laugh at me because he now knew he had me. And it was an hour and a half before he even called the police because he kept trying to get that killed. Thank you.
Thank you. Okay, open up the floor for discussion in this case, and during our discussion, we should identify aggravating and mitigating circumstances in this case or factors in this case.
Brian Stephan mitigating, she took her brother in at end of life to try to take care of him when nobody else would. Also mitigating, she does have a clean record, no discipline in her time in DOC.
And English for the record, aggravating was employed in a public safety position at the time of the incident.
Ted Langley for the record, as a mitigating factor, once law enforcement was involved, she did make proper notifications to the department.
Brian Stephan mitigating, she wouldn't give him expired medication that didn't belong to him.
Other discussion, aggravating, mitigating in this case? Jennifer, what do we have so far?
So far for aggravating that she was employed in public safety, mitigating that she took her brother in at the end of his life when no one else would, that she has a clean record with the DOC, that she made proper notification to DPSST after the criminal investigation, that she wouldn't give the medication to her brother that didn't belong to him.
Brian Stephan also mitigating, he rated it as a 4 out of 10 on the pain scale, and it was 0 when the police were there, and they did not see Mark.
Matt English mitigating, the case was dismissed ultimately.
Brian Stephan mitigating, she took ownership for her action.
Any other aggravating, mitigating? Hearing none, I would call for a motion to adopt the staff report, including the factors identified by the committee.
Brian Stephan, I move to adopt the staff report, including the mitigating and aggravating factors brought forth in the committee.
Mark Warren, second.
All right, we are voting on a motion to adopt the staff report. Chair English.
Aye.
Committee Member Boren.
Aye.
Committee Member Bowden.
Aye.
Committee Member Cameron.
Aye.
Committee Member Eby.
Aye.
Committee Member Frost.
Aye.
Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Stefan.
Aye.
Committee Member Reyes.
Aye.
Committee Member Shivers.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Thank you. Any further discussion? Hearing none, I entertain a motion for a recommendation to the Board of action or no action in this case.
Tabling for the record, I recommend the board take no action.
Mr. Chair, Aaron Rice for the record, I second that the board take no action.
Okay, thank you. We have a motion and a second to recommend no action in this case.
Voting on a motion to take no action. Chair English.
Aye.
Committee Member Boren.
Aye.
Committee Member Bowden.
Aye.
Committee Member Cameron.
Aye.
Committee Member Eby.
Aye.
Committee Member Frost.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Stefan.
Aye.
Committee Member Reyes.
Aye.
Committee Member Shivers.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Thank you. Thank you, Alistair. You are
Thank you.
dismissed.
Thanks so much.
Okay, we're gonna move on to Cody Carroll.
Yeah.
These are in this. Thank you. Melissa, I'll turn it over to you.
Thank you, Mr. Chair. Melissa Langbacho for the record. The department is presenting Deputy Carroll's case for consideration. Deputy Carroll is currently employed with the Jackson County Sheriff's Office and has applied for training. As part of the department's review process, LEDs and the Oregon E-Court records were reviewed to determine eligibility for training. During the review, the department identified a criminal disposition for theft 2 and that was not reported to the department on an application. Deputy Carroll's charge for theft 2 occurred when he was working as a security forces officer in 2014 with the Oregon Air National Guard after he intentionally took an envelope of money in a locked building he was tasked with securing. The theft 2 charge resulted in a civil compromise after the deputy paid the money back. Although it's not a conviction, it does meet the definition for a criminal disposition. The deputy's position in security forces qualifies as previous work as a public safety professional, which requires the review of the full committee instead of the applicant review committee. Deputy Carroll is here today to provide mitigation, and his case was previously reviewed by the committee in August, but has returned in order for the deputy to provide a mitigating statement. Mr. Chair.
I will turn it back over for a statement.
Thank you. Mr. Carroll, I have a timer here. Whenever you're ready to start, I will get started.
I thank you all for having me here today. I wanted to be here today in person instead of doing virtual, just to show you how much this means to me. I've always wanted to be in law enforcement since I was a small child. After high school, I ended up joining the Air National Guard as a security forces member, getting married, trying to build towards that dream that I had hoped for so long. During my time as security forces member, I loved everything that I did, but ended up falling into some hard times. Wasn't taking care of myself or my marriage, and so due to my actions and the theft of the money, it actually ended up in the discharge of myself from the Air National Guard. Because I was able to reach a civil compromise, I was able to obtain a general discharge with honorable conditions, which I have been eternally grateful for. And since then, I've strived on becoming better and holding myself to a higher standard that's going to meet what I want. And it's not only going to make me proud, but make everybody that depends on me proud. With this being in 2014, it's been nearly a decade. Since then, I've gotten a divorce. I've moved on from that portion of my life, and I've tried to set up a good foundation that I can build for myself and my kids. In 2015, I met my current wife. We've now been married a little over 4 years. I have 3 children. I have adopted her 17 and 14-year-old, and we have a 7-year-old together. I wake up each and every day, and I strive to do a little bit better to show them that people can make mistakes, and as long as you learn from them and you find a way to not recreate that incident, it doesn't have to define you forever. Don't ever forget it. Don't ever let the incident happen again. But I am a firm believer in forgiveness, not forgiveness. I'm here today to ask you to allow me the opportunity to serve my community and show all of the AICs that I am with every single day that just because you've made a mistake in the past does not mean you can't do good for yourself or for your community. I have been able to reach a lot of individuals that have been in custody by just admitting that I have had my own mistakes, I have my own flaws, and that doesn't define who I am, but it doesn't have to define you either. Just because you're on that side does not mean you can't turn your life around. And so I've asked that the 2 people that came up with me today is one of the lieutenants that we have in our jail and the sheriff of my county, Jackson County. To have them here as support in this room with me is, it's beyond words. Just to know that they're here for whatever decision is going to come down. But I have been very upfront and honest with my agency from the first interview that we had. I've been as humble as I can be about the situation. It has been nearly a decade ago. I do not believe I've had any other instances that would bring up a question of my character since. And as I've stated, I wake up each and every day and I strive to do a little bit better, give my kids someone that they can look up to and show that you can make mistakes, but you can overcome them.
Thank you. Okay, floor is open for discussion of this case and identifying any aggravating and mitigating factors.
Nick Hunter, aggravating by definition was a public safety personnel at the time. Mitigating is twofold. One, on Mr. Carroll's statement today, and several letters of support were received from Mr. Carroll addressing his character interactions, several factors, and those letters were received up and including Sheriff Sickler submitting a letter. So I believe that's a mitigating factor.
Aaron Rice, for the record, mitigating would be accountability and making good on the situation.
Jennifer Cameron, for the record, mitigating would be that it happened nearly a decade ago, or around a decade ago. Yeah, that's kind of cool.
Mr. Chair, Aaron Reyes, for the record, mitigating would be that the sheriff took time to come up here to show support.
Matt English for the record. Many of you that were on the committee or have been on the committee for a while probably remember hearing this case last year. There was a disconnect within the agency, which is the reason why it came back, so that there was due process. We had originally voted to take action in this case, and I've thought long and hard on this, the underlying crime was a theft. There's an element of dishonesty in theft, which would probably be an aggravating factor, but I've sat on this committee. I think I'm going into my year. I've never seen this many mitigation letters and letters of support. So where I'm left is, yes, those, there is an element, and technically he was in a public safety position, but it's a 19-year-old kid, and I guess I'm struggling with the fact that an action that you take as a 19-year-old can potentially define you now as a 28, 29-year-old that's in a public safety profession and clearly has agency and community support. So definitely mitigated the amount of Stickler's letter pointed out the fact that they have an arduous background process, that he was straightforward during all of that background, and that there was no question about him taking accountability for those actions that happened about a decade ago. So mostly mitigating. Additional aggravating mitigating. Hearing none, just call for a motion to adopt the staff report and the aggravating mitigating as identified.
Leave for the record, I motion that we accept the staff report as written along with the aggravating and mitigating factors as identified during the meeting.
Jennifer Cameron, I'll second.
Thank you. It's been moved and seconded to adopt the staff report.
We are voting on a motion to adopt the staff report. Chair English.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Cameron.
Aye.
Committee Member Eby.
Aye.
Committee Member Frost.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Stefan.
Aye.
Committee Member Reyes.
Aye.
Committee Member Shivers.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Thank you. Any further discussion? Then I'd call for a motion to recommend to the board that we either take action or no action in this case.
Levy for the record. I recommend, I put a motion that we take no action based on the mitigating factors that were presented during the meeting, in addition to the fact that he had proposed and talked about understanding what occurred, has changed his life over the years, and where he is now, along with the chair's speech about 19-year-olds, which I can appreciate and understand.
John Frost, for the record, I'll second that.
All All right, it's been moved and seconded to recommend to the board to take no action in this case.
We are voting on a motion to take no action. Chair English,
Aye.
Committee Member Boring,
Aye.
Committee Member Bowden,
Aye.
Committee Member Cameron,
Aye.
Committee Member Eby,
Aye.
Committee Member Frost,
Aye.
Committee Member Hunter,
Aye.
Committee Member Langley,
Aye.
Committee Member Stefan,
Aye.
Committee Member Reyes,
Aye.
Committee Member Shivers,
Aye.
and Committee Member Tabor.
Aye.
Motion passed.
Thank you, sir. Dismissed. Okay, we will move on to Klamath County Sheriff's Office, Randy Bocci. What's that? Okay, this is a case of Randy Bocci. I will turn it over to Melissa Lynn Boccio.
Thank you, Mr. Chair and committee members. The department opened a professional standards case for Randy Bocci after he applied for corrections training after being hired with the Klamath County Sheriff's Office. When reviewing the application for training, public records reflected a criminal disposition for hunting on cultivated and enclosed lands of another. The deputy was observed by the state police shooting ducks from a moving boat and entered private lands to retrieve some of the ducks. Deputy Bocci pled guilty and entered into a diversion agreement, and the charge was later dismissed after he completed the terms of the agreement. Deputy Bocci was previously employed in public safety and was removed from his agency while attending the academy at DPSST in 2005. His separation from the academy is included for the committee to consider as aggravating or mitigating information. The department found that Deputy Bocci violated the board's moral fitness when he violated criminal law and obtained a criminal disposition. He's here today to provide a verbal mitigation statement and submitted written information for the committee to consider. And Deputy, just a reminder that we'll have a timer here going for 5 minutes, and there won't be an opportunity to have a dialogue with the committee. It's just a statement that you're making, and I will start the clock whenever you're ready.
I'm ready.
Go ahead.
Good morning, ladies and gentlemen. Thank you for your time and consideration today. In regards to the academy in 2005, I was a fresh out of the Marine Corps young man, and I was long on ego and short on maturity, and quite frankly probably shouldn't have been in law enforcement at that time in my life. And I have lived with the regret of my actions at the academy during that time since then, and have spent my life trying to not only better myself but better those around me. In regards to the hunting incident, I hadn't bird hunted in years and was definitely not up to date on rules and regulations, which I should have been, especially since I was with a first-time hunter. I should have taken the responsibility to lead them and guide them in their first hunting experience, I was faced with a decision of retrieving a downed animal from a field or leaving it. And in my mind at the time, leaving an animal is a hunting ethical violation that's just not acceptable. So I made the decision to retrieve the animal, and I pled guilty to my actions of trespassing on another's cultivated land and did what I needed to do to clear that from my record. And I just have not only learned from that, but now I make it a point every year before I hunt to brush up on the synopsis so that I know that I'm doing the right thing. Again, I appreciate y'all's time today.
Thank you. Okay, the floor is now open for discussion in this case. During our discussion, we should identify aggravating mitigating factors in this case.
Mr. Chair, Aaron Rice for the record, mitigating would be, even though the behavior was inappropriate at OPSA, it was 19 years ago.
Ted Langley for the record, regarding the hunting and trespassing incident, I listed mitigating factor, the fact that he pled guilty and also went through the diversion program and took care of what the court ordered him to do.
Matt English for the record, mitigating. There are numerous letters of mitigation provided by the agency to include the sheriff, and the deputy has taken accountability for his actions both in 2005 and 2016.
Jennifer Cameron for the record, mitigating that we were here today and I did not hear any excuse making.
Nick Hunter, mitigating. I'll build on Mr. Chair's statement concerning those letters. The one that was most significant to me was not the one that was received actually from the sheriff, but the one that was received from Sergeant Justman, who completed the background. The letter submitted by him clearly states accountability and openness that Deputy Bocci did during that background, where kind of nothing was off limits, and we were just going to talk about the maturity issues. I especially appreciate the initial comment today about maturity, and that 2005 was not the right time potentially to be in law enforcement. It doesn't excuse the actions that took place, but it does take accountability and a realization of where he was at the time.
Any other aggravating or mitigating? Hearing none, I call for a motion to adopt the staff report and the aggravating mitigating is identified by the committee.
Mark Warren for the record, I'll motion to accept the staff record with the mitigation items presented.
Ted Langley, second.
Thank you. It's been moved and seconded.
We are voting on a motion to adopt the staff report. Chair English.
Aye.
Committee Member Boren.
Aye.
Committee Member Bowden.
Aye.
Committee Member Cameron.
Aye.
Committee Member Eby.
Aye.
Committee Member Frost.
Aye.
Committee Member Hunter.
Aye.
Aye.
Committee Member Stefan.
Aye.
Committee Member Reyes.
Aye.
Committee Member Shivers.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Thank you. Any further discussion? Hearing none, I would ask for a motion to recommend to the board that they take action or no action in this case.
Mr. Chair, I would make a motion to the board that we take no action in this case based on the mitigating factors and discussion that took place.
Thank you.
Mr. Chair, Aaron Reyes for the record, I second.
It has been moved and seconded to recommend to the board no action in this case.
Voting on a motion to take no action, Chair English,
Aye.
Committee Member Warren,
Aye.
Committee Member Bowden,
Aye.
Committee Member Cameron,
Aye.
Committee Member Eby,
Aye.
Committee Member Frost,
Aye.
Committee Member Hunter,
Aye.
Committee Member Langley,
Aye.
Committee Member Stefan,
Aye.
Committee Member Reyes,
Aye.
Committee Member Shivers,
Aye.
and Committee Member Tabor.
Aye.
Motion passed.
Thank you. Thank you for your time.
Thank you very much.
And then is Mr. Sundin here?
Yes.
Okay, and that would be our last in person, is that correct? Okay. We'll move on to that. It's number 12 on our agenda.
Mr. Chairman, John Tabor for the record. With this upcoming Sundin case, I have a question with regard to whether or not I should recuse myself from this case. I was involved in the use of force review that took place as a result of the incident at EOCI. Also had extensive conversations with both Mr. Sundin and with the folks who terminated him. So I'm wondering if I should just recuse myself from this.
Kathleen Calpin for the record. No, you don't have to based on things that you've identified, but by identifying the potential conflict, it's stated for the record, but that is not one of the criteria for recusing yourself.
I'm sorry, I was unable to hear the last part of what you said.
That is not one of the criteria for recusing yourself. But thank you for stating it for the record.
Thank you very much.
Okay, we will now consider the case Timothy Sundin, presented by Jennifer Lavario.
Thank you, Chair English. Jennifer Lavario for the record. Case before you is that of Timothy Sundin. On February 15th of 2023, Timothy Sundin was terminated for cause by the Department of Corrections Eastern Oregon Correctional Institution after investigation by the DOC Special Investigations Unit, DOC Human Resources, and the Oregon State Police into allegations of misconduct. DOC found that Sundin violated numerous policies after he deployed fluorescent capsicum spray on an adult in custody. From here on out, I'll call it OC spray. OSP cited Sundin with official misconduct 2, a Class C misdemeanor, and use of a stun gun / tear gas / mace 2, a Class A misdemeanor, and referred the case to the Umatilla District Attorney. The DA charged Mr. Sundin with official misconduct in the 1st degree, unlawful use of a stun gun, tear gas or mace in the 2nd degree, and attempted assault in the 4th degree. On June 7, a jury returned a verdict of not guilty on all charges, and Mr. Sundin was acquitted. On June 9th of 2022, the DA emailed the Assistant Inspector General at DOC reporting his concerns related to multiple Brady issues with Mr. Sundin's reporting and testimony in the court cases. On April 9th of 2023, Mr. Sundin was hired by the Umatilla County Sheriff's Office as a deputy sheriff, where he is currently employed. The department determines Mr. Sundin's conduct violated the board's moral fitness standards as follows. Dishonesty. Mr. Sundin provided inconsistent statements during his criminal trial and was untruthful in his report and testimony related to the deployment of OC spray on an AIC, adult in custody, at the DOC EOCI. Misuse of authority. Mr. Sundin used his position and authority as a public safety professional to harm an AIC by deploying OC spray without legitimate reason or correctional objective. Misconduct. Mr. Sundin harmed people and efficient operations of the agency when he deployed OC spray without a legitimate reason or correctional objective. The department submits its determination to the policy committee to affirm, modify, or negate its moral fitness violations. Mr. Sundin, are you prepared to provide your statement?
Yes, ma'am.
Just a reminder that this is not a dialogue with the committee, just a 5-minute statement.
Okay.
Okay, go ahead.
Well, thank you for allowing me to come here today. And another thing is that I should have had this done a long time ago, but I got it extended for some family deal, and I appreciate that. You know, I've worked for DOC for 23 years, and my whole career I went from an officer to sergeant within 5 years, and worked SEG a lot. I sprayed a lot. I even was working under a lieutenant in the DSU where this occurred, and I don't, I mean, I followed all rules and statements, gave orders. They deleted videos, they took down videos, they edited them. I've never had a letter in my file, never had a bad eval in my whole 23 years that I was in corrections. Worked with a lot of people, I've worked with a lot of AICs, and I've never been dishonest. I was never questioned in the court of law when I was in court. They never questioned my integrity or any of that until I was acquitted, and then they started coming after me and attacking me and trying to find any little thing that I did to put letters in my files and show that I was that guy that steps out of line. But in my 23 years, I've never ever even crossed my mind that I would step out of my scope of employment ever. Never lied. No, and that's one thing they taught us when we were hired. You lie, that's pretty much your career. And so obviously they're trying to show that my report did not match the video, obviously, because the video that I set up was a handheld camcorder that we use on cell extractions. And I set it up because the guy was half nuts. He tried to hang up the night before he got out on cell, and I set it up for our reason of trying to finish our duties the day. And you write your report, they have an overhead camera that shows everything in that segregation unit. And that's what you base your report on. Well, this camera was set up about 7 to 10 minutes later, so it didn't catch everything that I wrote, so they're saying that I was dishonest on that because I was based it on that. I have a lieutenant in there that gave me basically the green light because I told him that I wasn't gonna allow him to, mess up his unit. So they left me out front, I couldn't go inside. They tried to go back 3 months on a cell extraction to put a letter in my file. They said I sprayed twice. Clearly in the report, in the court report, it only shows me spraying once. A deployment form, when you spray OC spray, you gotta fill out a deployment form. And it's something you have to do, you can't just let it go. They say I didn't even do that. I got it signed by my lieutenant. I mean, he was in there that day. I mean, you have to fill it out, you have to do that. And they said that wasn't complete, and I have that, and it just, I don't know, it's just something that I can't really fathom in my 23 years that I've been that far, and then I get this, so that's about all I got to say.
Thank you, Mr. Sun.
You're welcome.
Okay, we will open this case up for discussion, and our discussion should include identifying any aggravating or mitigating.
Mr. Chair, Aaron Reyes, for the record, aggravating factor would be that the OC was used in a manner that was not reasonable and outside the policy of the Oregon Department of Corrections.
Mr. Chair, I'll add to that statement as well. Not only was it outside the policy of the Oregon DOC, it was outside of the 8th Amendment when we're talking about Hudson McMillan, or it was outside of the 4th Amendment when we're talking about Kingsley Hendrickson. And so I think the aggravating factor is still no accountability being shown at all to taking the action which was unlawful by Mr. Sundin.
Ted Langley for the record. I heard him make a statement saying that the lieutenant basically green lighted it, and I think it just goes with the last two statements that are made, that even if a supervisor says it's okay, if it's an unlawful order, it's still an unlawful order, and it still behooves you to make that decision and, in this case, not follow it.
Brian Steffen for the record, aggravating he pointed out how important it was to him that he kept his word, and in the report it states that he had told the AIC if he didn't stop he was going to spray him. When the AIC did it again, he went into the room and the AIC, or into the area, the AIC stopped and backed up, and he said, I told you I'd spray you if you did it again, and then sprayed him, basically keeping his word. But it amounted to corporal punishment rather than achieving the legitimate correctional objective, which had been achieved when the AIC backed up and stopped.
Nick Hunter, aggravating. The initial statements provided by Mr. Sundin as the case continued, he provided additional statements to try and justify his actions when we talk about the portions of it becoming, he was quelling something that was possibly going to happen, and also the language about whether it was the security device, talking about the food court or another security device. Those were statements that were added in that were not part of his initial reporting.
Ryan Steffen for the record, according to the report, the district attorney for Umatilla County feels he will not be able to use him in court, will not be able to rely on any statements that he makes in court proceedings.
Matt English for the record, I think that the way I read that letter, it was a concern letter. I don't think that was an actual Brady letter. And I will also, frankly, when I read that letter, I found it mitigating because I was just concerned about the tone of that letter because it was going after every single person because they lost the case, is the way that it read to me. But that was just my personal opinion.
John Tabor for the record, aggravating. The lack of accountability I find to be really troubling and disappointing.
Any further discussion? Jennifer, would you read back our aggravating mitigating?
For aggravating, I have that the OC was used in a manner not reasonable and outside the OC policy. In addition to that, it was outside the 8th and 4th Amendments, in other words, unlawful. There's no accountability provided. Even though there was a green light given by the lieutenant for the actions, if the actions were unlawful, it's still the responsibility of the officer not to follow them. Trying to read my writing here, excuse me. He said in his statements that he told the AIC that he was going to spray him, and he kept his word. In other words, he kept his word even though the AIC backed up after he said, I'm going to spray you if you continue, which was similar to corporal punishment, since the AIC had in some way kind of complied with that order. his initial statement, there was additional statements made after the initial statement that appeared to be justifying some of the actions that he, some of the statements he made in his initial statement to justify some of his actions. The DA's concern email was seen as both mitigating and aggravating. The DA felt concerned for being able to use this officer in court as aggravating. Also, there was a tone in the DA's email that was concerning in that it seemed to be going after many people involved in this investigation. And once again, just a lack of accountability, which was disappointing.
Any additional aggravating or mitigating in this case? Hearing none, call for a motion to adopt the staff report and the factors identified by the committee.
So, Lenny, for the record, I move that we adopt the staff report with the listed aggravated and mitigating circumstances that were mentioned.
Mark Warren, for the record, I'll second.
Thanks.
All right, we are voting on a motion to adopt the staff report. Chair English?
Aye.
Committee Member Boren?
Aye.
Committee Member Bowden?
Aye.
Committee Member Cameron?
Aye.
Committee Member Eby?
Aye.
Committee Member Frost?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Steffen?
Aye.
Committee Member Reyes?
Aye.
Committee Member Shivers?
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Thank you. Any further discussion? And I would entertain a motion for a recommendation from the committee to the board whether to take action or no action in this case.
Mr. Chair, I'll make a motion that we take action in this case based on the aggravating factors that were just listed.
Okay, there's a motion by Sheriff Hunter.
I'll second that motion.
Second.
For the record.
All right, voting on a motion to take action. Chair English?
Aye.
Committee Member Boren?
Aye.
Committee Member Bowden?
Aye.
Committee Member Cameron?
Aye.
Committee Member Eby?
Aye.
Committee Member Frost?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Steffen?
Aye.
Committee Member Reyes?
Aye.
Committee Member Shivers?
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay, so discussion or motion, I should say, on recommended action to the board, amount of ineligibility in this case. So that first motion should include why the specific timeline is being recommended.
Mr. Chair, I'll make a motion that we take action. The specific timeline would be lifetime ineligibility. I'm going to base that recommendation on the complete lack of accountability for this action, continuing up through the statement that was given today. There's still no accountability for the actual action that was taken itself. And I think that action has clearly been shown that it was an unlawful action. So based quite simply on the dishonesty and the accountability portion, and the dishonesty came from, as the investigation went, the statements changed. And so those two things lead me to my recommendation for the lifetime ineligibility.
And Matt English, for the record, just so there's clarity on the record. So for misconduct, we can only recommend up to 10 years, but for if there's a dishonesty component, that can be a recommendation for lifetime ineligibility. So there is a motion on the floor for lifetime ineligibility based on the dishonesty.
Committee Member Frost, I'll second that.
Okay, it's moved and seconded for lifetime ineligibility.
We are voting on a motion for a lifetime ineligibility period. Chair English.
Nay.
Committee Member Boren.
Aye.
Committee Member Bowden.
Nay.
Committee Member Cameron.
Aye.
Committee Member Eby.
Nay.
Committee Member Frost.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Nay.
Committee Member Steffen.
Nay.
Committee Member Reyes.
Nay.
Committee Member Shivers.
Nay.
Committee Member Tabor.
Nay.
Motion failed.
Okay, so the recommendation for lifetime failed, so we would entertain another motion since we have voted to recommend action, so for a different ineligibility period.
Levy, for the record, I would motion for an eligibility period of 10 years based on the misuse of authority misconduct that was described in the aggravating factors based on the use of force at the time of the incident.
Thank you. So there's a motion on the floor for a recommendation of 10-year ineligibility period.
Brian Steffen, for the record, I'll second.
It's been moved and seconded.
All right, we are voting on a motion for a 10-year ineligibility period. Chair English.
Aye.
Committee Member Boren.
Aye.
Committee Member Bowden.
Aye.
Committee Member Cameron.
Aye.
Committee Member Eby.
Aye.
Committee Member Frost.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Steffen.
Aye.
Committee Member Reyes.
Aye.
Committee Member Shivers.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay, thank you. Thank you, sir. You're dismissed.
I'm sorry about that.
Okay, we will move back into the agenda, agenda item number 4, Ruben Benavides. And that is presented by Jennifer Lovato.
Thank you, Chair English. This is case Ruben Benavides. On August 15th of 2020, Ruben Benavides resigned from the Oregon Department of Corrections in lieu of termination by way of an agreement between his attorney and the DOC. Benavides was under investigation at the time for multiple Prison Rape Elimination Act allegations, or PREA, and had been verbally confrontational with staff, including pulling a staff member's hand off of a button he was pushing to close a cell door. In May of 2017, the department reviewed conduct involving Mr. Benavides' termination from DOC after allegations of fighting with DOC corporals, one turning physical. This termination was overturned through arbitration and the department administratively closed the case. Mr. Benavides had 5 civil complaints filed against him for the conduct reported at DOC. 3 had been settled and 1 is in default at the time of this report. The department determined Mr. Benavides violated the board's moral fitness standards as follows. Dishonesty. Mr. Benavides engaged in intentional dishonesty by misrepresenting the truth when questioned about showing sexually explicit photos to AICs. Mr. Benavides was intentionally dishonest during past investigations into his involvement in sharing confidential information with a fellow officer and his actions related to the inappropriate changing of the Telmate PIN numbers of AICs. Misuse of authority. Mr. Benavides used his authority as a corrections officer to intimidate AICs by subjecting them to sexually explicit photos and comments, threatening retaliation, and engaging in intimidating physical conduct. Misconduct. Mr. Benavides engaged in threatening conduct to AICs by subjecting them to sexually explicit photos, making retaliating statements, and engaging in retaliatory physical conduct. Mr. Benavides harmed the safety and security of the DOC facility by engaging in a verbal confrontation that included pulling an officer's hand off of a button he was pushing to close a cell door. Mr. Benavides violated numerous DOC policies and its standards of conduct resulting in several disciplinary investigations that threatened the efficient operations of the agency. Mr. Benavides harmed AICs by tampering with their Telmate PIN numbers, making it impossible for them to make phone calls. The department submits its determination to the policy committee to affirm, modify, or negate its moral fitness violations. Chair English.
Thank you. Open the floor up for discussion in this case and to identify aggravating mitigating factors.
So, I'd say, I just want to start by saying, with all the cases I've seen, I was like overwhelmed by the abuse of power with some of the things that were listed in this case. Willingness to have conflict with peers and people that were the corporals who outranked him, and his willingness to lie about his actions were the two biggest aggravating factors for me in the
Mr. Chair, Ms. Reyes, for the record, aggravating subjected AICs to sexually explicit photos, which would be in violation of PREA, as they don't have the ability to consent by law. Mr. Chair, Aaron Reyes for the record, to add to that, the dishonesty throughout the investigative process would be an aggravating factor as far as I'm concerned.
Brian Steffen for the record, also the willful disregard when people were trying to correct him and put him in the right direction. He absolutely was consciously resistant to that.
Mr. Chair, Aaron Rice for the record, the sections of the statute for official misconduct are met with his conduct and behavior with the telemate changing the PIN, using his position to deprive AICs of their right to make telephone calls outside of the institution.
Other aggravating, mitigating? Jennifer, could you read back what we have so far, please?
I only have aggravating, an overwhelming abuse of power, fighting with his peers and higher ranking officers, lying, dishonesty throughout his investigation process. He subjected AICs to sexually explicit photos, which are PREA violations. His willful disregard when people were trying to correct his behavior, his resistance to that. There were elements, the elements of official misconduct were met when he tampered with the PIN numbers of the Telmate system.
Any other aggravating, mitigating? Hearing none, I would entertain a motion to adopt the staff report, including the aggravating factors identified by the committee.
Brian Steffen, I move to adopt the staff report and the aggravating factors from the committee.
Mr. Chair, Aaron Rice for the record, I second.
Thank you.
All right, we are voting on a motion to adopt the staff report. Chair English?
Aye.
Committee Member Boren?
Aye.
Committee Member Bowden?
Aye.
Committee Member Cameron?
Aye.
Committee Member Eby?
Aye.
Committee Member Frost?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Steffen?
Aye.
Committee Member Reyes?
Aye.
Committee Member Shivers?
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Thank you. Any further discussion? And entertain a motion to recommend to the board whether they should take action or no action in this case.
Jennifer Cameron, for the record, I recommend action be taken.
Thank you.
Maybe for the record, I second that motion.
Thank you. It's been moved and seconded to recommend action in this case.
All right, we are voting on a motion to take action. Chair English?
Aye.
Committee Member Bourne?
Aye.
Committee Member Bowden?
Aye.
Committee Member Cameron?
Aye.
Committee Member Eby?
Aye.
Committee Member Frost?
Aye.
Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Steffen?
Aye.
Committee Member Reyes?
Aye.
Committee Member Shivers?
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Thank you. Now entertain a motion, recommended ineligibility period in this case. Since we have identified dishonesty, it can be up to a lifetime recommendation to the board.
Mr. Chair, Aaron Reyes for the record. Due to the dishonesty, the PREA violations, the alleged behavior or the actual founded behavior against the AIC population and physical staff members, I would recommend a lifetime revocation.
Brian Steffen, I second.
Thank you. It's been moved and seconded to recommend to the board a lifetime revocation in this case.
All right, voting on a motion for a lifetime ineligibility period. Chair English?
Aye.
Committee Member Bourne?
Aye.
Committee Member Bowden?
Aye.
Committee Member Cameron?
Aye.
Committee Member Eby?
Aye.
Committee Member Frost?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Steffen?
Aye.
Committee Member Reyes?
Aye.
Committee Member Shivers?
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Thank you. Since we have a significant amount left on our agenda, would anybody object to about a 5-minute break to stretch your legs? Okay. Take 5. Are you gonna time us, Jennifer?
Starting now.